Okay, well, thank you for choosing to attend this workshop which Jennifer Gray kindly agreed to put on the agenda for today. You'll have seen the blurb, which is this. We have a failed system that doesn't hold the government to account, and the establishment has the temerity to say we live in a democracy, whereas the EU is anti-democratic. Nothing could be further from the truth, as we shall explore in this 30-minute session. We actually live in an elected dictatorship, which is incredibly difficult to alter should bad actors or disingenuous people occupy the great offices of state. And this topic cuts much deeper than any change to the voting system that we've discussed a lot as Lib Dems. And we haven't discussed this topic really until now. This session will set out the grounds for a written constitution and a constitutional court, which my colleague Sam Evans is going to talk about, with powers to remove governments that are not keeping to their manifesto pledges. But it's an interactive session, so we'll be taking questions from the floor at the end, and we'll be looking at your thoughts on the benefits, practicalities and difficulties of such a system. Okay, well, so I'm Nick Hind, and I wanted to put this topic onto the agenda because it really comes to something that in 2022 that this conversation is even necessary. Hello. You might say that this all started during the referendum campaign back in 2016 when Vote Leave wanted Britain to take back control. However, the actions of the executive has magnified the problem since that time. It's worth noting that other than legislation to remove the supremacy of the EU, very little has changed in terms of our governance, aside from some of the things that were mentioned in the last session about civil rights. And that's despite the passing of our late Queen, who obviously is the constitutional monarch. What did change? In terms of legislation, we had the Fixed Term Parliaments Act, which us Liberal Democrats were instrumental in creating, and that was repealed. We had the European Union Withdrawal Act of 2018, which was introduced, and that repealed the European Communities Act of 1972. What's changed in terms of leadership? Well, we've had 5 prime ministers in the space of just 6 years, with 2 general elections and a balanced parliament from the election in 2017 until Johnson's majority victory in December 2019. Let's just touch upon some of the issues that have happened since 2016. If you remember, Theresa May negotiated the Brexit deal in virtual secrecy, saying that she wouldn't give a running commentary and Parliament would have the chance to scrutinise the deal once agreed with the EU. The reality was that Parliament was actually given very little time to scrutinise that deal, and when it did, it voted it down, not once but twice, which led to her resignation and ushered the Johnson era in July 2019. Of course, he still had the same parliamentary arithmetic that she had after calling that disastrous general election. So what did he do? He illegally prorogued Parliament, as the date for our withdrawal from the EU on the 31st of October 2019 got ever closer, and he simply couldn't get his business through the House of Commons. So he called a general election, which unfortunately he subsequently won with an 80-seat majority, which sealed our departure from the EU on the 31st of January the following year, and then the pandemic struck. In April this year, Byline Times published an article listing 8 significant manifesto promises that were broken by Johnson. We will not raise national insurance. We will keep the triple lock and other pensioner benefits. No one should have to sell their home to pay for care. We will build the Northern Powerhouse rail link between Leeds and Manchester. We will build 40 new hospitals across the country. We will keep our existing energy cap and introduce new measures to lower bills. We will proudly maintain our commitment to spend 0.7% of gross national income on development. And we will host the UK government's first ever international LGBT conference. Those are 8 pretty significant things that were promised by Johnson, completely broken, and there's no way to bring that to account. And this was before disastrous Liz Truss came along. You might remember at the Tory party conference, Greenpeace had a little protest when they held aloft a banner asking who voted for this. They identified at least 7 areas across environmental protection, climate action, workers' rights and tackling inequality, where policies either confirmed or being considered by Truss and her ministers, this is when she was doing the campaign over the summer, were at odds with the 2019 Conservative manifesto. So, and that's just it with everything we're discussing now. The events have been such fast moving with the changes of Prime Ministers that it's hard to keep up with it. However, the sad pantomime didn't stop there. It had a direct effect on people's mortgage bills as confidence in the UK economy nosedived, forcing Liz Truss to sack a Chancellor before being forced out herself just a few days later. Why does all this matter? Let me ask you that question. Why does all this matter? And my answer is, it's at the very cornerstone of democracy. We elect politicians on the basis of the legislation they wish to enact. If you can't trust what people are going to say and do, then what is the point? There are deeper issues as well that we won't really discuss here, such as the way many millions of pounds of contracts were dished out to companies without proper procurement procedures being followed during the pandemic. This matters because not only, as that wonderful infamous phrase, the will of the people goes, not only is the will of the people being ignored, but pockets are being lined. So, in my opinion, that's the problem. Commitments that are made, commitments aren't kept, and other than MPs actually voting them down, what can we do about it? What's the solution? So, it's clear that we need something more to protect the integrity of our democracy. And I think that's come about because of the people we've had in charge. If you had honourable people in charge who actually did the things that they said they were going to do, this wouldn't be necessary. We have a famous unwritten constitution that involves Parliament, government and the judiciary. Obviously, it's no secret we have a top-down level of governance in this country, with national parliament derogating certain powers to county councils, district councils, and then that drops further down the chain to parish councils. Unlike in other countries, we don't have a presidential democracy, we have a parliamentary democracy, where members of parliament get elected, and within each party, a leader is chosen from those elected members. So the question now is, are the checks and balances? In the judicial sense, we have a Supreme Court, which sits above the Crown Court and the High Court, and passes judgments on matters referred to it. These would normally be single-issue cases, such as when dear Boris illegally prorogued Parliament back in 2019. In the parliamentary sense, the only bodies that are able to exert any power are members of Parliament themselves, the House of Lords. However, this does not have supremacy following the Parliament Act of 1911, and the monarch. Of course, we have a constitutional monarchy since the Civil War back in the 1640s, and therefore the sovereign is essentially just a rubber stamp rather than a check or balance. If we had a constitutional court, it would be a new mechanism strengthening our democracy. I'm going to ask Sam Evans, who is a lawyer, to give you some information on what a constitutional court would look like, how it would be distinct from the Supreme Court, and some points, some pluses and some positives and negatives about how it could operate.
So thank you very much all. So unlike Nick, I've not prepared an actual script, so I'm going to have to sort of wing it off the little notes I've got. But so in brief, when we talk about a constitutional court, what is it that we're talking about? So effectively it would be a court that would preside over issues of constitutional law and make decisions on that basis. And the court would not focus on cases of criminal or civil litigation in the sense that the Supreme Court can consider at the moment. So just a bit of background to the Supreme Court that's currently in existence. So it was set up in 2009 under the new Labour government following the Constitutional Reform Act of 2005. The aim of the Supreme Court was to further separate powers between the executive, the judiciary and Parliament. And it achieved that in one way of actually physically locating itself away further from the other institutions as well. As previously our highest court for UK law was actually the House of Lords, and by renaming to the Supreme Court and moving away from the House of Lords, it's helped further that separation of powers. In some ways, people could argue that the UK Supreme Court is already a constitutional court in the fact that it's already ruled on matters of constitutional law. However, it is widely viewed as a Supreme Court itself and not actually a specific constitutional court that other countries have. So if we look at some of the positives and negatives and points to consider for arguments for and against the Supreme Court, the Constitutional Court, some points to consider is that as I said, the aim of the UK Supreme Court was to increase the separation of powers. And to help keep politics and law separate. However, we have seen in recent years politics and law clash as the court's been engulfed in attacks by the media and politicians. So, for example, many of you might remember the Daily Mail headline in 2016, which had pictures of 3 High Court judges titled "Enemies of the People," which was incredibly dangerous for our democracy that a major newspaper could do that. And it was attacking the High Court justices on the basis of a decision they'd made about Article 50, which then went to the Supreme Court, and the Supreme Court ruled that Article 50 must be triggered by Parliament itself rather than a specific minister. And that was the first case that Gina Miller, which many of you might know, brought to court. We've also seen more political influence and argument that surrounded Brexit that led to court decisions as well, with the case deciding that Article 50 could be unilaterally revoked rather than the European Union and the UK agreeing one party could unilaterally, well, the UK itself could unilaterally revoke that. And we also then had the second Miller case, which was the case that Nick mentioned about the prorogation of Parliament. And following the case where the Supreme Court said, no, you cannot suspend Parliament, and actually in our position, you have not suspended Parliament. Parliament was never suspended, and it's resitting, was their decision. That saw attacks by Conservative MPs, and some of them even called for the abolition of the Supreme Court as well. So one thing to consider about a constitutional court would be the influence of politics and whether that might actually end up leading to us having elected judges, would be a point to consider. Recent reforms for the Supreme Court itself, when the Supreme Court was introduced, we had the Judicial Appointments Commission, which was set up to help select members of the Supreme Court with not having the political interference of actually being appointed. And I think that's one point, I think, to consider quite carefully if we look at Constitutional Court. If it's increasingly going to be ruling on constitutional issues that could be interpreted as political, is that going to lead to people calling for judges to actually be elected or appointed? And if we actually look at the US Supreme Court, for example, with the recent decision of Roe and Wade being overturned, and the fact that in the US, the judges themselves come from different parties and are appointed on that basis, I think it's a key point to look at. And in my view, I think it's quite dangerous if we appointed judges politically. I would rather they be appointed on the grounds of actual qualification. So, if we were to make the Constitutional Court, one thing to consider would also be what powers it would have. So if it can rule on constitutional legislation, would it be able to set aside that legislation itself? I know that Nick, we're going to talk a bit later about the power of removing governments that don't follow manifesto commitments, which we can tie into that. And if we do give a constitutional court the power to set aside legislation, how is that going to conflict with parliamentary sovereignty? Would Parliament then be able to clash with the court and override it? It's another sort of point to consider when we're considering a constitutional court. And also, how should it be implemented? How could we go about implementing this constitutional court? Could we do it by referendum? There's an argument that it will be democratic by doing so, and in recent years we have had referendums on constitutional issues, such as Brexit, the Scottish independence referendum, the 2011 AV referendum, and the devolved government referendums that Tony Blair had as well. However, if we look at the introduction of the Supreme Court itself, it was introduced by parliamentary legislation, the Constitutional Reform Act 2005. That did not have a referendum itself. So one thing to consider would be, how do we go about implementing a constitutional court? And is there therefore a basis to actually have it on democratic means in that sense, from a referendum, or in our parliamentary system have it implemented from a manifesto commitment? And then some other points to consider would be, for example, if the reforms were implemented democratically through either a government winning a significant majority on the basis of implementing that court or in a referendum, and the reforms meet with public approval, that could also help actually strengthen the court itself, which is one of the points to consider. A constitutional court could also act as an effective check and balance against executives, and it could also codify powers and restrictions of the constitutional court if we are looking to make a written constitution as well. We could have that set out, written down for people to understand, rather than mass amounts of case law and different statutes scattered about, so everybody can sort of appreciate the role and the powers that actually the constitutional court would have. And the last point to consider is, in a post-Brexit world, with the less influence of EU law and the Court of Justice of the European Union, now might actually be the time for us to actually consider looking at the supremacy of the Supreme Court and whether we should actually set up a constitutional court to judge on constitutional issues. So I'll now pass back to Nick, and then he can talk through the next part of the talk. Thank you.
Thank you, sir. So, essentially, we've developed a system of government that relies on the decency and honour of those who are elected to fulfil the great offices of state. But the difficulties between elections, we essentially have an elected dictatorship dependent upon the majority of the governing party at any one particular time. This isn't necessarily a new issue. There have been grumbles in the past. Some in here will be old enough to remember Margaret Thatcher's kitchen cabinet in the early 80s, which was given that moniker because it was essentially stuffed full of unelected advisors. I think Sir Alan Walters was one of them. And so the problem that we're seeking to examine here is the danger posed when politicians promise certain things in a manifesto and then either deviate from those promises or use excuse of circumstances to follow a different course. This is and has been especially prevalent during a change of leader, as we've seen several times during the past couple of months, let alone the administration since 2019. We discussed a constitutional court, but if that's to have any bearing, there would need to be a written document for it to determine. This could be an act of parliament or a written constitution. So let's just take a look at what that is. UK Parliament's website defines a constitution as the set of principles and rules by which a country is organised, and it is usually contained in one document. In the UK, a constitution has never been codified in this way. Instead, the various statutes, conventions, judicial decisions and treaties, which, taken together, govern how the UK is run, are referred to collectively as the British Constitution. Whenever we discuss a written constitution, there'll be some disquiet, of course, because of the example provided by the United States. The most obvious example being the right to bear arms, known as the Second Amendment, which has allowed, or should we say enabled, school shootings to go unabated because of the influence of the gun lobby, pointing out the rights of its citizens to defend themselves as enshrined in their constitution. Now, a quick look on Wikipedia shows that the overwhelming majority of the countries have a codified constitution, with only about half a dozen not having the same. We, of course, are one of those. There is obviously a vast difference between constitutions, as the word count in them, which is listed quite handily, shows. India's is the longest in the world with nearly 146,000 words, which is more than double the next longest, which is Nigeria's with a mere 66,000. Whereas Monaco, Iceland, the United States and Denmark all have constitutions that are less than 7,000 words long. So there are several things that we might look at in this regard. Firstly, a constitution need not be set in stone necessarily. You could have a sunset clause, so you could write a document and it might last for 25 years rather than 200 years, because some of the problems that we see in the United States are from something written in the 1700s. And that would allow time and society to evolve. Sometimes less is more, and a constitution could just set out the relationship of the executive to Parliament and the judiciary and matters pertaining to elections and conduct. I'm going to ask Sam just to come back quickly to speak about how powers might be given to remove governments that break manifesto commitments.
Thanks, Nick. So if we're to consider powers that could be used to remove governments where they don't follow their manifesto commitments, there's a few considerations that we need to take into account and exceptions we need to consider. For example, if we're to give a constitutional court or the Supreme Court itself the power to remove governments which break manifesto commitments, will this further blur the lines between politics and the judiciary, for example? We'd also need to consider what exceptions would apply. So in the event of a hung parliament, for example, would governments therefore be allowed to break manifesto commitments as they're not elected on a majority basis? Or for example, as we've seen with COVID, would governments therefore be able to break manifesto commitments for frustrating events that have come up which have significantly changed the state of the economy? And another consideration to make would be, if we are to exercise the power of removing governments, what would happen in that event? Would we go straight to an election, for example? Or would the king still have the prerogative power to appoint somebody else as leader? Or would we have some form of route, such as what exists in the Fixed Term Parliaments Act, where the Commons would have a number of days for a successor to come forward who commands the majority of the House before an election is therefore called? And also, a thing to consider as well is, if we're to consider using this power to remove governments who break manifesto commitments, what do we determine as actually breach of a manifesto commitment itself, and how major would that breach actually need to be for the power to be exercised to remove the government? So that's just a few considerations to make when thinking about that power. Thank you.
Thanks, Sam. Okay, so it's a workshop. I'm keen to get your views from the floor about what you've heard and your thoughts before I close. So any questions and comments I'm keen to hear.
So the first one about the Constitutional Court, other than the cases put to it, is there any real material difference to that of the Supreme Court? And if not, is it just a case of workload that we've split it out? Or is there a material reason why you need to split it from the Supreme Court?
I think that's a brilliant point. I think a constitutional court itself would only focus on the constitutional issues, so there wouldn't be, for example, cases of civil litigation, any family law cases, any criminal cases that would go to it, such as what happens with the Supreme Court, for example. So at the moment, the Supreme Court rules on all bases of all types of law, including constitutional law. And I think there's an argument for the Constitutional Court being a separate entity to actually focus on just specific constitutional issues, which would also help avoid the Supreme Court and judges being accused of political influence and being dragged into anything like that. So I think that's one sort of argument for actually having a Constitutional Court separate from the Supreme Court, just to focus purely on those issues. So if Nick has any points on that.
I wouldn't disagree with that at all, actually. I mean, I think the reason I would say to have something which is separate, even if similar judges sat on it, is so that the public could actually see that there was something that was called a constitutional court, which sort of looked at matters in a written constitution, whereas at the moment there is just not that thing there. There's not that body there. So I'd also say I'm very keen. I wouldn't want a system where it got politicised, such as in the United States, where it was Democrats, and I wouldn't want it to be Labour judges and Conservative judges. That's something that I think we should be very clear to avoid, because I don't think that would be good for where we're at.
Sorry, I may have missed it. Can you clarify who would have, standing to present something to the court, if at all? So how would a case come before the court? So you mentioned how Gina Miller herself brought something to the Supreme Court.
Yes.
How would this work in the case of the Constitutional Court?
I would think a similar kind of way, that you would have a Bill of Rights or an Act of Parliament, and it would contain, it need not be particularly long, but when things when there was something that contravened something within that, so manifesto commitments being the obvious one, when you had a situation where Liz Truss basically said, we're not going to keep to what was in the 2019 manifesto, we're going to give tax breaks for the rich and the wealthiest. Well, very clearly was not actually within the bounds of what the kind of things that were promised. And so it could be on, for instance, on health grounds. If it's quite clear that where are these 40 hospitals that you promised, and listening earlier today in the main auditorium to David Nicholl speaking about those 40 hospitals, there doesn't even seem to have been a plan to get there. There's a lot of talk and rhetoric, but it's actually about saying, well, hang on a minute, where's the delivery with this? So I think it's got to be, we've got to be careful, but I think there's got to be the rights for government to actually set out what it's going to do and then start delivering on those. And so, for instance, the court could say, we need a plan of exactly what you're going to do, for instance, with the delivery of 40 hospitals, or else you're not actually keeping to that commitment.
And I'm just thinking about how would a case be initiated, I think, is what I'm thinking.
So on your point on standing, so who is actually allowed to actually bring a claim against the government in that sense?
Who would do that,
Yeah, I think we'd have to be very careful on not allowing the power to be too wide, in the sense that I think we couldn't have the Constitutional Court constantly having people bringing claims on any basis. So I think we'd have to be very clear in the legislation that we set out who can bring a claim. My personal view is I'd be happy for private individuals to be allowed to bring that on the basis that it's similar to sort of how we have judicial review currently, which I know there has been changes to recently. But I think that's a really interesting point you've raised, actually, because we have to be careful of the floodgates argument, if anybody can bring a claim, but also living in a democracy and, how can we therefore deny citizens the right to bring a claim against their government? So it's a fantastic point. I think it's something that needs a lot of discussion, really, to make sure we balance those issues, really. Yeah.
Thank you.
Number one, with a manifesto, I think we can't be too insistent on that, because the world changes, the life changes, the issues change, so there's got to be flexibility. On the other hand, not up yours and do something completely different. But the bit that interests me is the written constitution. I agree at the moment, we need something that rebalances power. But who writes it? And what I assume about a written constitution